We have two cases on the calendar for today, and we'll hear the cases in the order in which they appear. I assume counsel has had the clock explained, so there's no issue there. If you will let us know the time you want to hold for rebuttal when you start, we'll try to remind you without interrupting. Citizens for Better Government versus the City of Panama City.
If it please the Court, Doug Boykoff for the appellants, I'd like to reserve 3 minutes, please. It's beyond dispute that the legislature is presumed to have meant something by the laws that they enact. And if the Florida legislature meant anything by a duly noticed public meeting in section 163.380 subparagraph 2, if there is not a duly noticed public meeting, then someone certainly has the right, a member of the public, for a public meeting. The amended complaint that was filed in this case alleged in paragraph 4, D, E, and F, paragraph 17, paragraph 35, 36, and paragraph 37 that the plaintiffs were not afforded a duly noticed public meeting and that they had suffered injury by the lack of that duly noticed public meeting.
But is that injury the type of special injury that provides the appellant standing? That's the question.
Certainly, Your Honor. And this Court has issued many opinions on various types of standing. And as we all know, standing can be created by statute, by the Constitution, and in some cases by administrative rule. And then there are judicially created standing opportunities. In this particular case, the legislature has said that the city must have a duly noticed public hearing, ostensibly so that the public can attend this hearing. Otherwise, it wouldn't say a duly noticed public hearing. It would say, for example, the city may, without a hearing, notice to anybody, go ahead and approve the sale of this property. There'd be no requirement to have any notice or a public hearing. And in fact, the various cases that have been cited to you in the briefs, for example, the Combs case out of the second, the Court goes over the fact that by ordinance there, the city of Naples had determined that those people were entitled to notice by ordinance. And here, the legislature has determined that the city shall provide notice to the public in general.
But in the Combs case, wasn't a summary judgment ultimately granted in that case on standing?
That was actually Smith 2, Your Honor.
Okay.
That was Smith 2, which my research did not disclose, and I apologize for that. However, the issue of whether or not this statute, which says a duly noticed public hearing, means anything at all. If it means anything, it means the public has a right to this hearing, and if they don't get a duly noticed public hearing, there has to be a remedy. Otherwise, this statute would have no meaning whatsoever. It wouldn't need to be there, and the law presumes that the legislature did in fact mean something when they adopted this.
So is there a difference between the public hearing required under the General Sunshine Law that applies to all governmental entities and this provision of 163 that you're talking about?
Well, I think that the trial court is ultimately going to be faced with that sort of a question as to whether duly noticed, and the statute in 163 does not define what that means, whether it just means your regular public notice.
Because it seems to me that you pled a 163 violation, but you didn't necessarily plead a Sunshine Law violation.
That's correct. We didn't necessarily, although it could be encompassed within that. And certainly a dismissal with prejudice means that we could never allege a Sunshine violation, for example. But I think it's for the trial court to determine whether duly noticed in 163.380 means the same thing.
But doesn't the Combs case actually tell us something here, because in Combs, the court made a distinction between plaintiffs who owned property adjacent to their club, and they were complaining about the notice of a public hearing, and plaintiffs who were not an owner of property in the vicinity of the club, allowed standing for people who were the property owners in the vicinity of the club, but denied standing to the others. And so doesn't that go back to the special injury that has to be shown? And I'd ask you again, what type, other than being a member of the public or a resident of the city, what special injury do your clients have here?
Your Honor has posed two questions. The first question, I believe it is clear from the opinion in Combs, and I'll quote, "The Combs' own property adjacent to the club and are within the class of property owners the city determined should be provided notice of the public hearings pertaining to approval of the development agreement." It's very commonplace for cities and counties to adopt a radius. If there's going to be a land use change within a certain radius, whether it's 400 feet in some jurisdictions, 1,000 in others, and every property owner within there is by their ordinance entitled to notice. State law only requires, for a zoning change, for example, publication in the newspaper and posting of a sign. Most local jurisdictions give specific particular notice to people who live within a particular radius. So I believe that answers the first part of Your Honor's question.
So your argument then is any member of the public, in a case where you have a requirement of public notice, any member of the public has standing?
Yes, Your Honor. Otherwise, the statute would be meaningless.
And what authority do you have for that proposition?
Well,
Specific authority.
the Combs case deals with a local ordinance, which defines standing in terms of, I believe it's apparent, people who owned property within a certain distance of the property affected by the development agreement. The Webb case, for example, which is, I believe, a First District case, Webb versus the town of Hilliard, which says strict compliance with the notice requirements of a statute adopted by the state, in that case particularly dealing with zoning changes, must be adhered to. But practically, I think that in my years of experience in arguing standing cases even before this court, standing can be created by a constitution, statute, the court, or an ordinance. In this case, the legislature said there shall be a duly noticed public meeting. Now, they could have said there shall be a public meeting notice to members of or residents of the city or residents of the county, which would have narrowed the pool of people with standing, but the legislature did not choose to do that. So based on what the legislature has given to us and trying to construe it, by its plain terms, it says public. So in this particular instance, I believe that any member of the public who can allege that they did not get notice of this hearing, or that there wasn't due notice given, would have standing to have that hearing.
Can you distinguish the facts of this case from the second DCA's holding in Smith 2?
Smith, I don't believe, particularly argued this specific point, and I don't believe the decision particularly centered on that. And really, the Smith holding, as well as the multitude of cases cited in the answer briefs, deal more with taxpayer standing and whether a taxpayer has, absent constitutional allegation, standing to challenge a discretionary act of the government. And the Supreme Court has said no on various occasions. And that is not the appellant's position here today, and was not the position before the trial court. And in fact, this case is very similar to the Lynnhaven case, which this court determined some years ago. In Lynnhaven, in spite of the fact that this was not, the Lynn Haven appeal was not an administrative appeal, this court relied on various associational standing cases that deal with administrative rights and remedies, and found that the Architectural Association, in that case, had standing on behalf of its members to require competitive bidding compliance, in spite of the fact that that organization did not hold an architectural license and in and of itself was not entitled to any special dispensation. In this case, we tried and alleged very specifically the interests of the members of this organization in regard to historic preservation, and that's this train depot specific matter. And the complaint is very detailed in the interests of this organization as well as the interests of its members, and in that regard established an additional ground of standing, although this case is not about necessarily the ultimate decision of the city or the Downtown Improvement Board to dispose of this property. Ultimately, if this court reverses the trial court, the plaintiffs have the opportunity to prove they were entitled to a duly noticed public hearing.
But counsel, can you tell us why the members, CBG members' interest in the depot are any different than a member of the public at large?
Yes, Your Honor. A member of the public at large, as opposed to Citizens for Better Government, does not have necessarily as its raison d'etre to preserve historic buildings, which is one of the specific purposes of Citizens for Better Government. The members of the general public do not necessarily earn their livelihood, like some of the members of Citizens for Better Government, from creating works of art based on that building. The members of the general public may or may not have the specialized interests that these people have. And that's no different than the Florida Ophthalmologic Society or the Bay County Association of Architects, who have a specialized interest. If the court doesn't have further questions, I'll reserve my time. Thank you.
May it please the court. My name is Lisa Hamlin. I represent the City of Panama City and the Panama City Downtown Improvement Board. First, I would like to respond to a couple of the arguments that counsel made. Chapter 163-380, the statute that we're talking about here, the notice provisions of which they have alleged that the city violated, or rather the Downtown Improvement Board violated, doesn't have a standing requirement. And the second DCA has held that in that second Smith case that common law standing applies to alleged violations of the notice provisions in Chapter 163-380. So there is no exception for notice statutes or that I'm aware of, and to hold differently would be in direct conflict with Smith too. And counsel, in his own brief, recognized that the Smith case is on all fours factually with the instant case. They also were questioning the notice provision. They said that the city had violated it. It involved a transfer of property. It was for a declaratory judgment action. And in the first Smith case, to which he initially cited, the court didn't address standing, but they did allow him to proceed, which seemed to imply that they had addressed standing and decided that he had standing. But in Smith 2, the court goes back and specifically states that they did not address standing, that they were addressing it now. They distinguished the Combs case they pointed out the same point that I would like to make, since that's the case he's mostly relying upon. Combs dealt with a statute that does create standing. Statute 163.3215 has been recognized by many courts as liberalizing the common law standing requirement. And they were interpreting the plaintiff's interest in that case within the confines of the statute. So it's really not applicable to whether or not they would have had common law standing. And I also would like to point out that in the Combs case, there was one plaintiff who did not own property adjacent to the property that was in question. And the court held that common law standing rules applied to him. He had to show a special injury, and he had not. Now, they did allow him to proceed under the one recognized exception to the common law standard, which is if someone is questioning the constitutional taxing and spending that exception that is set forth in, I believe it's the Horn case. But that is, again, inapplicable here because that is not the section that the appellant is traveling under.
Do you agree if this had been brought under the Sunshine Law that he would have not had to prove separate and distinct injury to have standing?
Well, I think that Sunshine Law, the 280 whatever, has as its own standing requirement, and he didn't. And I would like to point out too, this is his second complaint that's been dismissed. That's why it got dismissed with prejudice. The first order stated that the special injury requirement existed and that he was given leave to replead and whatever. And so he has had two bites at the apple in an effort to attempt to plead special injury significant enough in differing from the general public in both degree and kind. And the main crux of his argument, it seems to me, has been that, yes, these people may care more about what happens to the train depot, so they may be affected to a larger degree, but that is not sufficient to meet the standard for special injury. A subjective sense of loss is not a key to the courthouse, I believe, is the way that Judge Hess, the trial judge, phrased it.
What about the appellant's argument relying on our Lynnhaven case that the organization here, Citizens for Better Government in Bay County, is similar to the group in the Lynnhaven case?
That case is totally distinguishable from this case in that the special injury requirement applied the same way that it does here, but in that case the plaintiffs were able to establish they had a special injury in that they had a statutory constitutional right to be able to bid on public projects and to be able to, that right is protected by statute. In this case, these people are laying claim to a piece of city property around which they don't own it, they don't own any property around it, they don't have any legally protectable right. What they are questioning, attempting to question in the courts, is the governmental decision as to what was the best decision regarding the spending of government resources. And in that instance, the courts are simply not the appropriate place to question that. Your remedy is to vote the people out that made a decision you didn't like. That the courts, that's the reason for the standing rule. Otherwise, government would grind to a standstill if every citizen who disagreed with a government decision could run in and sue. That's why the special injury requirement is there.
What about the Chapter 119?
The Chapter 119, that, as outlined in my brief, changed from one complaint to the next. In the first complaint, they complained only about the delay, not the documents that were produced. In the second complaint, they did complain about...
Well, I mean, certainly he could, when he's repleading, he can replead.
So, yeah. But the second complaint was the first time that we were ever notified that they were complaining about the content of the production. And he attached to his complaint the basis. One was Diane Brown, who he did allege was a member of the organization, and then one of the named, Mr. Creel, who is a named plaintiff. Mr. Creel's production requests, which were done only in his own name, the court pointed out that based upon the face of the pleadings, he received all the documents he requested. That's in his affidavit that's attached to the complaint. So it's part of the pleadings.
Counsel, at what point does a public entity's delay in producing documents pursuant to a public records request become unreasonable? 1 week, 1 month, 2 days?
Well, in this case, it was 4 days. So as he's alleged, the person whose office the records resided in was out of town, and I believe they requested them on a Thursday, and they got them on a Monday. And our position in the original hearing was that wasn't unreasonable. And in any event, they weren't requesting a motion to compel or mandamus action for the documents to be produced. They were only asking for attorney's fees.
Is 30 days unreasonable?
Depends upon, I suppose, the circumstances. It's not reasonable if it is an automatic delay. Courts have held that to be the case, but I think it depends upon the circumstances. But in this case, Ms. Brown, you don't even have to get to that decision because Ms. Brown is not a plaintiff or a party to the lawsuit. And if you look from the face of the pleadings, her request was not done in the name of this organization. It never mentioned this organization. It was a personal public records request. And even in her affidavit she prepared, presumably in preparation for filing this thing, she still never mentioned, I did it on behalf of citizens or anything. So the trial court held that maybe not, Ms. Brown might have had her own public records issue, but she's not a party to the lawsuit and chose to not be, and therefore the group has no standing to, has no standing to pursue her claim that she may or may not have. So, as I said, the other thing I wanted to say is that they didn't plead the sunshine violation, and that is again standing that's set out by statute, but that's not what they're traveling under, and they had 2 opportunities to plead that and notice that it existed and whatever, and instead they are traveling purely under this 163-380, and Smith 2 is exactly on point factually. They even, when you read it, they go through and distinguish paragraph by paragraph the cases upon which the appellant is relying upon. The court goes through and says why those arguments do not apply. And with respect to the issue of whether or not they have sufficiently pled, assuming for the purpose of argument that they have to show a special injury, it is our position and was held by the trial court both times that the allegations that they have set forth are simply not sufficient. And I would point the court to the Sand Key case or the Sarasota County Anglers Club case. One of them involved people who like to go to the beach, and they were upset that the person who owned the beach was going to put a fence around it, and they said, oh, no, you can't do that. And the court said, well, you don't have standing just because you want to be on the beach and continue to use it. You don't have a legal right to exercise it over property that does not belong to you. And the same sort of reasoning was used in the Sarasota Anglers Club. In that case, it involved dredging where people had traditionally fished, and they were upset that it was going to upset the fishing, that there would be no more fish, it would drive the fish away. And they said, though all citizens have a right to the bottoms and do have a right in the same way that I suppose that the city's property is the property of all citizens, you don't have a right to have it remain unchanged forever. That's what your elected officials are there to decide. So, do you have any more questions? If not, I would ask that the court affirm the trial court's order dismissing with prejudice both counts, both the public records request and the lack of standing.
Thank you, counsel.
May it please the court. My name is Doug Smith. I'm with the Burke Blue Law Firm in Panama City. We represent 456th Street LLC, which is the entity which owns the train depot property now. 456th Street LLC is only a party to one of the counts, and that's the one that deals with the standing issue. We don't have any role to play in the document production issue. All we would say is that we agree with the position taken by the city. We believe the Smith 2 case is on all fours. There is no special injury alleged in this matter. And inasmuch as 456th Street LLC would like to know that it has valid ownership of this property purchased about 1.5 years ago, it would like to move forward, and it would like to ask this court to affirm the circuit court in all respects. Thank you.
In rebuttal, if I could first address the Chapter 119 issue. Chapter 119 nowhere contains any requirement that a person identify themselves. It contains no requirement that a person identify on whose behalf they are requesting the examination of public records. In fact, it just says, and the Constitution provides, that any person has the right at any time to inspect, copy public records. And the only allowed delay is for the custodian of the records to gather them together for inspection and assert any exemptions. In this case, the amended complaint and its attachments and exhibits indicates that numerous requests were made. They were made to the chairman of the Downtown Improvement Board. They were made to the personnel in the office. They were made to the executive director. And there was, in fact, at least
but let me make
a
sure
4-day delay.
that the complaint, the requests were made by Ms. Brown and Mr. Creel. Is that correct?
That's correct.
And Ms. Brown's not a party to this action.
She is alleged to be a member of Citizens for Better Government, a corporation which can only act through people.
And is it alleged that she made the request, the public records request, as an agent of the corporation?
Construing the amended complaint in the light most favorable to the appellants, plaintiffs below, the complaint clearly alleges that Ms. Brown and Mr. Creel, members of Citizens for Better Government, made public records requests. And certainly the Supreme Court has held in Tribune Company versus Canella that a 72-hour delay, as a matter of course, is illegal and unauthorized. All the other cases and Attorney General opinions that have reviewed that question have all said that automatic delays are unauthorized and that the only permissible delay is the time to get the documents and provide them for inspection. That didn't happen in this case, and it's squarely alleged that it did not occur. A valid cause of action for Chapter 119 has been stated. The Lynn Haven case is very analogous to the instant matter because that organization of Bay County Architects had no right to bid on that project in and of itself. There's nothing in the opinion to suggest that this association had an architectural license. Indeed, it could not. Thank you.